I don't know that I would call it compliance assistant, right? I mean, it really does feel like an audit, but I think, that framing is kind of important because, E-Verify has long argued, this is not an audit. These processes are intended to be educational, collaborative, but increasingly, to your point, Nick, I think, they've kind of changed a little bit.
Welcome to Statutes of Liberty, an immigration podcast brought to you by Klasko Immigration Law Partners. The United States is many things: a great melting pot, a nation of immigrants, a land of opportunity. Millions have journeyed here seeking freedom and the chance for a better life. Belief in the American ideal means providing opportunities for everyone, regardless of race or birthplace, to achieve their highest potential. Join us as we unravel the ins and outs of immigration policy, from the issues of today to the historic basis for laws already in place.
Welcome back to Klasko's Statutes of Liberty podcast. This is the Worksite Compliance series, coming with the 5th edition of our series. I'm your host, Nick Lowrey. I'm a senior associate in Klasko's Washington, D.C. office. I'm joined today by John Fay at Equifax. Needing absolutely no introduction, Equifax is one of the 3 major global consumer credit reporting agencies, but Equifax also provides a broad suite of worksite solutions, including I-9 and E-Verify solutions to tens of thousands of customers. Equifax is really one of the large players in this space. And we have today John Fay, who is Director of Product Strategy at Equifax. John Fay, 20 years of experience in the space. He's given hundreds and hundreds of presentations, even several hundreds more publications on the issue. We're very glad to have him. John is not only an attorney, he's also a technologist. I think that is what is most interesting about John's background. He really comes at this compliance space from a technology forward perspective and has a really interesting perspective in that way. John Fay, welcome to the pod.
Thanks, Nick. Appreciate that very generous introduction. I am really excited to be with you all here today. I am, I guess, as you described, I-9 all the time, but today we'll branch out a little bit, I guess, with E-Verify. But I'm looking forward to the conversation.
So great to have you, John. So, John, during our series so far, we have talked about the basics of I-9 compliance. What does ICE enforcement look like? What do HSI notice of inspection entail? What are warrants? What are raids? How should employers be thinking about all of these different aspects of worksite compliance to really prepare their organizations, big or small, in the event that the government comes knocking at their door? Today, as you mentioned, I want to focus for our listeners that are E-Verify participants a little bit for them specifically, and what types of enforcement actions they could expect, how they should be thinking about compliance, and specifically in terms of the E-Verify practices, how they can be kicking the tires on their compliance program. So I'd like to start with just a few moments, John, to kind of lay the foundation. What is E-Verify?
Yeah, absolutely. So E-Verify is a web-based system. It is an extension of the Form I-9 process that allows participating employers to confirm the eligibility of their newly hired employees to work in the United States. It actually dates all the way back to 1996 when legislation was passed that essentially approved a pilot program, right? And so the whole idea behind E-Verify is, in the I-9 world, you're meeting with an employee, you're reviewing documents, you're determining, okay, does this document reasonably appear to be genuine? Does it relate to the person? But we don't have a lot of certainty with that process, right? I mean, how does an employer know? How do I know that this person actually is authorized to work? And so the idea behind the E-Verify system was, hey, the government has all this information. We've got Social Security numbers, we've got records, we've got Department of Homeland Security records. let's have this gigantic interconnected database, and let's allow employers to check it, right? And we'll essentially give them a green light if it's employment authorized, or if there's some sort of mismatch in the process, we'll guide them through that. So, that's really kind of the whole structure around E-Verify, kind of as a concept. But what makes it, I think, interesting is the fact that it's not nationally required. It's still largely a voluntary program, except where it's not. And we can go into that if you like. But that also creates a little bit of complexity as well.
Yeah, I mean, John, I give a lot of talks on I-9 compliance. We always get questions about E-Verify. I think that it really is an organization by organization determination, as you mentioned, unless it's not. Federal contractors, there are certain requirements for participating in E-Verify. I think that we have seen kind of nods from the current administration of looking to expand requirements for E-Verify. Right now, John, just for any listeners that may be tuning in that are not E-Verify employers, when is it required? Just to kind of draw a line for folks as we currently stand.
Yeah, absolutely. So, right now, as you mentioned, there are certain requirements for federal contractors. So, specifically, if you have a very specific type of contract, it's called a FAR contract, or Federal Acquisition Regulation contract, and it has what they refer to as the E-Verify clause in it. It will require you, since you're doing business with the federal government, to use the E-Verify system for not only your new hires, actually, but also anyone who is working on that contract. This can also get some subcontractors, as well. There's a flow down provision. So that's kind of one segment. Another segment is state law. So there are, roughly about 2 dozen different state laws throughout the country. I'm in Arizona, so we were one of the first ones that will actually require employers that have employees within the state to use E-Verify. So some employers will get pulled into the E-Verify requirement that way. And then there's two others that are worthy to note. They're not necessarily requirements per se, but if you want to use the E-Verify system, or excuse me, if you want to uh, do what they refer to as kind of the remote document examination, the alternative procedure, sometimes we refer to it as virtual. If you want to do that process, one of the requirements is you have to be an E-Verify participant in good standing. So, and then kind of the last area that I'll mention with respect to when an employer might be required to use E-Verify is if you are employing individuals, foreign students on F1 OPT, and you want to take advantage of the STEM extension, then you also need to be an employer that is using the E-Verify system. So those are kind of the major buckets of when you currently might use this as a solution.
Very helpful, John. And I would just underscore, as I mentioned, this, it really is a case by case decision. If your organization is considering using E-Verify, absolutely reach out to counsel, reach out to an expert, make sure that you're speaking through what are the pros, what are the cons. One thing that I always like to highlight for the clients that I speak with, E-Verify is not a safe harbor. And so it doesn't mean that you can just simply, sign up for E-Verify, train your people on using it, and then simply kind of turn off the document review scrutiny button for your organization. Because if the government investigates you and they find that you have fraudulent documents, they are not going to care that E-Verify came back with a work authorized determination. It's not a defense in that way. It's a very helpful tool, I think, in many circumstances, but it is not that type of shield in the event of enforcement. To that point, John, what I want to spend most of today's session on is talking about what E-Verify enforcement measures there are. What I have seen over the past year is kind of a spike in what is known as desk audits. And I'm getting more and more inquiries from clients or prospective clients that have received these desk audits from E-Verify. Maybe, John, if you could just give us a flavor, what is a desk audit and what does it entail?
Yeah, absolutely. So desk audits have been around for actually about over 15 years. It's essentially the way the agency describes it is a monitoring and compliance process by E-Verify staff when they suspect either some sort of potential misuse of the E-Verify system or non-compliant activities associated with an organization's use of E-Verify. And I would say, in many ways, desk audits, I think they reflect E-Verify's evolution, right? So early on, the government was all about, okay, let's sign up as many employers as we possibly can. Let's get them using the system, understanding how it works. And then as participation grew, I think the focus started to shift to whether employers are actually, using the system correctly. There are, a variety of different rules. Some of them are obvious, some are not. And of course, we see a variety of different levels of compliance when employers are actually using the E-Verify system. And so I think that's, kind of a big part of that. And by the way, we should probably note, because I think it has some significance, that the official name of this process, if you're Googling it or searching for it, is E-Verify Desk Review, not audit, which is interesting because the official tagline is that an E-Verify Desk Review is a compliance assistance tool that consists of phone calls, emails, interviews, and document exchanges between E-Verify account compliance and E-Verify employer participants. A lot to unpack there, but if I, as an employer, receive phone calls, emails, interviews, and document exchanges from a government agency, I don't know that I would call it compliance assistant, right? I mean, it really does feel like an audit, but I think that framing is kind of important because E-Verify has long argued, oh, this is not an audit. These processes are intended to be educational, collaborative, but increasingly, to your point, Nick, I think they now they've kind of changed a little bit. We've seen some changes in the program during the last year or so, and it really is feeling much more like an audit.
I think that's a really important call out, John, and it really contextualizes, I think, the importance of this episode, the timeliness of this episode, because we're really in a different kind of enforcement environment right now. And, E-Verify has always been kind of touted as an employer assistance program. And now, the government is kind of using it to identify unscrupulous employers or what they perceived to be unscrupulous employers. And so, you mentioned a little bit about what could trigger an audit, misuse of the program, the tool itself. What, can you dive a little bit deeper into what you mean by misuse of E-Verify? Like what actually triggers an audit?
Yeah, and so typically, from what we've seen, these types of audits arise from organizations who essentially get flagged by the system. So the agency has a data analytics tool, which they implemented some time ago. Surprise, surprise, your E-Verify information is being data mined. And typically what happens is if you violate any of the kind of core E-Verify rules, so maybe you have a few cases that are submitted late, or let's say you get a mismatch, what is referred to as a TNC or tentative non-confirmation, and you don't take action on it within the required time period, or you have a final non-confirmation, which is when the E-Verify system essentially, throws its hand up and saying, "Sorry, we can't verify this person's employment authorization," and the employer doesn't do anything about it, right? They just leave it open. That's when essentially kind of the first stage of the process. So when that any one of those types of quote unquote non-compliant behaviors happen, in many instances, you as an employer will receive an email. This is an automated email from the E-Verify system. And you'll get like a list of cases where this has occurred. And what we've been told in the past, I mean, there's not a lot of clarity regarding exactly what this is based on. But what we've been told in the past is if that pattern or behavior, whatever it is, continues for, let's say, the next 60 days, that's when you can become, as an employer, a candidate for an E-Verify desk review. And of course, there are a variety of other non-compliant behaviors that could happen, but those are just a few of the examples.
Very helpful, John. Before we dive into the kind of substance of the desk review, you mentioned you get an email, but how does the process generally unfold from your perspective? I would say in the 90% kind of bucket of cases, what is the interaction like? Are you seeing emails and phone calls and in-person interviews, or is it an online document sharing process? What do you generally see as part of this review?
Yeah. So if we go down kind of the path, so let's say again, you have some sort of issue at your organization has prompted these initial emails, which, at this point, kind of the tone and tenor of the email is more just like, hey, we want you to be aware of this, this potential issue. In some instances, it'll say, you don't have to contact us. It's very, kind of gentle at this point of the process. But then if you reach that, threshold, whatever it is, where the government is saying, okay, there's definitely a problem here. What we've seen most recently is employers will receive sometimes phone calls, and then they will receive an email. And this email is kind of the first formal notice that they've been selected for a desk review. And what's interesting about it, at least to me, because I've been following it for so many years, initially when we were seeing these, it was more kind of like, hey, you've been chosen for a desk review, we're going to be happy to go over your program, your process. And
Congratulations.
yes, exactly, right, you're you're one of the lucky few. And it was more like, do you want to do this? And I know that because I remember we used to have clients that say, well, should we, and then we would always, say, oh, you should speak to your counsel, and there was a variety of different considerations involved. But now, there's no, if you want to do this, it's if you do not do this, we will proceed with potential termination. So, it's a very different kind of feel to it now. It's like you've been selected for a desk review. And then what we've seen more recently is they explain the process, and they send you a bunch of attachments. And so they want to know, they send you like this company profile form, which you're expected to fill out. They send you a self-assessment questionnaire, which they also expect you to fill out, or at least in some instances will expect you to fill out. And then they actually have a request. And what we've seen is this is typically about 20 or so e-verify cases and in many cases, these are the ones or examples of ones where they observe some sort of non-compliant behavior, and they'll want to see a variety of basically everything. They want to see the I-9, they want to see supporting documents if you've retained them. They'll want to see e-verify reports, they'll ask for payroll reports. And that's when again it really starts to feel a little bit more, like a traditional Form I-9 audit.
Yeah, it's very helpful. I will say from my perspective, what I have found is you're absolutely right. Email 4 or 5 attachments, what appears to be quite a bit of instruction, a relatively vague instruction, and not a true roadmap for how to effectively respond, whether that's intentional or not. And what I have found is, especially for larger employers that are working with e-verified web service providers, right? They have a company that's helping them manage their e-verify. That process, if the employer doesn't have some sort of protocol in place, the initial kind of day or several hours after receiving that audit can be relatively confusing. And so I think, the first thing that I always recommend is, have an escalation protocol. First, make sure that your I-9 team is aware that this could come, because firstly, a lot of organizations get these emails and their response is this even real? Because they're getting you don't trust any emails anymore. You have every single email account has a report phishing button on it.
Right.
And so there's always that immediate question of, is this real? And so have an escalation protocol, be able to reach out to, external counsel, or escalate within your general counsel's organization, or at least know who senior leadership should be aware that this came in, and make sure that you're working closely with your web services provider, because they're really going to be able to provide you much of the documentation that you need to respond. So you gave us a flavor of what is generally requested. I'm often seeing about the same, about 20 I-9 profiles or employee profiles requesting for I-9s, E-Verify printouts, and sometimes a variety of other documents. I have seen, listing of employee records. What I would like to know, John, is what is what is actually the end goal for these audits? And I know that that depends a little bit in terms of what triggered the audit, but what is generally the end goal? Like, what is being scrutinized when an employer gets a listing of 20 employees that they need to provide files for?
Yeah, and that's a great question, and just like you implied, it definitely, I think, depends largely on some of the issues that have been spotted or really triggered the audit to begin with. What we've seen in terms of the recommendation report. So, what happens procedurally, at least in the cases where we've assisted clients, is after everything is turned over to the government, shortly thereafter, and actually in very quickly in many instances, they receive this recommendation report, which is a little bit of a misnomer because part of it is really not recommendations. It's this is what you need to do. But we've seen it broken down generally into two different areas. So there are discrepancies and then observations. The discrepancies are things where the agency feels like, okay, you're not following the E-Verify rules and requirements, and that might essentially frustrate the purpose of the program, right? So if we go back to the beginning of the podcast, the whole idea behind this, at least from the government's perspective, it seems, is let's increase the accuracy, let's increase the compliance of employers, and ultimately, of course, the reason behind the requirement to have an I-9 is to ensure that employers are not employing unauthorized workers. So, what we've seen are the types of issues that could lead to the hiring or employment of unauthorized workers. So, a few examples: one would be tentative non-confirmations mismatches, where the employer has not taken the required action, has not, gotten the employee to say yes, I'm going to contest, or no, I'm not. They're just sitting there. The agency refers to these internally when I've spoken to them as hanging TNCs. And so if an employer has any of those and they haven't been following up, that is one of the things they're scrutinizing. Because again, this could, imagine a situation where somebody actually wasn't work authorized and the employer went through this process and they're saying, well, we're E-Verify participant, but if they're not following the rules, the government feels like, oh, this is a loophole. We need to close it. So that's one. Another, which is kind of related to it, is those final non-confirmations. So when you're using E-Verify, if for whatever reason the government can't resolve a case, or maybe the employee doesn't take action within a required time period, you'll receive a final non-confirmation. And as part of that process, you as an employer have to close the case and you have to indicate, okay, you know, what happened, where the employee has been terminated, or we're going to continue to employ them, whatever the case may be. And so if those are unresolved, that would be another thing that we've seen flagged in these audits. And then some other things which are kind of interesting and are actually a little bit new is lack of E-Verify training. So if you are using a E-Verify web services provider, you do not generally get access to the E-Verify website. You're creating I-9s in the system. Your I-9s are being submitted through an integration through that system to E-Verify, and so there's no tutorial, there's no training of the users. Instead, that has to be performed either by the employer or by the agent. And so, as part of these, they'll request proof that you have actually trained all your E-Verify users, that they've taken a test, they passed the test, and if for some reason you haven't done that, that's another thing we've seen being scrutinized within the last year or so. And that's entirely new. Like I said, I have not seen that level of scrutiny before.
John, I think that that is such an important call out. And the reason why I say that is it is not clear based off of E-Verify's guidance what that documentation should look like, right? When you complete a training, you're not receiving certificates mailed to your office that says, congratulations, John Fay completed his training. Um, you so it is really incumbent upon the employer to be documenting their compliance with the memorandum of understanding to be able to respond to these audits. Because if you get one and they ask for documentation showing that the training was completed, and you don't have any documentation, and then you create documentation in that moment, well, you know, what is the credibility of documentation that is developed in response to the request? It's low, and so I think that is a point that is a really big takeaway for any listener that their organization is using E-Verify. Make sure, one, that you're reviewing your memorandum of understanding, and two, for the training requirements, that you are really documenting that you are meeting those requirements, because John is absolutely right. This is something that we are consistently seeing as parts of these reviews. So really, really good call out. John, you and I had a conversation before this that I wanted to quickly bring up, which I think ties back to an earlier point that you made of kind of the different tenor that we're seeing these reviews in comparison to how E-Verify has operated historically. You mentioned something about a change in the response time frame for employers that are receiving these reviews. What are you typically seeing when E-Verify reaches out to an employer in terms of a requirement for response?
Yeah. So in some of the early ones that we saw, I think it was about a 10 business day requirement for actually, you know, assembling all this information, the I-9s, the E-Verify reports, the further action notices and payroll records and all that sort of stuff. More recently, we've seen a few clients where now that has been reduced to 5 business days. Again, it's interesting, only because, we're used to, at least within the I-9 context, the 3 business days being at least relatively stable concept, where this is a little bit different. Now, I have seen, and this is maybe something where you can comment too, Nick, but I have seen some employers been able to get extensions that may depend upon, extenuating circumstances, who they're dealing with, and that can be helpful, especially if you're have a lot of different parties involved, if you're using a web services provider and perhaps you don't have access to that information. But those are some of the things I'm seeing. I'm curious, what have you been seeing?
Uh, exactly the same, kind of towards the end of last year, a drop to 10 business days, and more recently, a drop to 5 business days. I wanted to bring this up specifically for the last point that you made, John, which is that it's important that employers at least consider having counsel ready to serve as an intermediary, because those types of conversations, those types of requests for extension, you don't want that to be a reflection of the company, right? Having a buffer, by having external counsel, allows for that type of negotiation, I think, in a much more natural way. I have not had any pushback from E-Verify when I've requested for extensions. They're generally relatively accommodating. They have an officer assigned to the particular review, and that officer will generally respond within a day or so with what the extension timeframe looks like. But it's all the more reason for companies to have protocols in place, because you don't want to be figuring out whether you can be doing these things after you've gotten the audit request. You want to have it, a plan in place so that you can action immediately, because, John, as you mentioned, there can be several different parties involved, and collecting documents internally is difficult enough, especially for very large organizations. And it can be even more difficult if you're working with a third party web services provider. So, a really good point. I really wanted to bring it up because I think it's really a key takeaway for our listeners. Aside from meeting a response deadline or potentially requesting an extension, are there any do's and don'ts as a part of this process? Like, are the companies that you're working with generally making corrections to their I-9s? Have you seen E-Verify mention any sort of issue that they're taking with employers correcting I-9s, or running E-Verify if they see folks haven't been placed through E-Verify? What generally are you seeing for the companies that you're working with?
Yeah, I think one of the things that I would recommend, and I'll basically echo what you said about getting counsel involved early as possible, is you know don't don't assume that the government's conclusions are always correct. And I say that because we've had instances where the agency's findings or the data was perhaps just wrong, right? We had a client, this was a few years ago, who was properly enrolled as an E-Verify FAR employer, but they still got dinged for verifying existing employees, even though they were properly enrolled, right? And so, we have to remember that in many instances, the basis for these reviews, for these audits, is simply data, right? It's data that is calculated and run. The agency is probably also looking at a report as well, and sometimes that information can be incorrect. So I always encourage employers to review those specific records, make sure that the agency's findings are correct, and that there's nothing that is perhaps complicating things, or instances where we've seen all kinds of things, right? I mean, sometimes employers have multiple E-Verify accounts. Sometimes they've acquired companies. Sometimes they've got multiple electronic I-9 and E-Verify systems involved. There could be a variety of extenuating circumstances that could have led to an issue. And so, generally speaking, I find the ones that are most successful are not reflexively, making corrections just again based upon this notice, but are analyzing it, but are reviewing it, pulling up the records, again, speaking with counsel, figuring out, what happened. Because, just like with I-9 audits, and I'm not sure if you covered this in your previous podcasts, but, sometimes you can make matters worse if you overcorrect or you try to fix something that perhaps wasn't correct to begin with. We always have to remember, just like with I-9, E-Verify has rules and responsibilities that are designed to protect employees, to protect them from being overly verified, from over documentation. And so, again, it's just a good idea. You get this report, analyze it, look at it, speak with counsel, and figure out your strategy from there.
Really, really good call out. I mean, I think because of the automated process, it is particularly important that employers, as you mentioned, are not just taking the government's word for it, because you're right. You can make it worse by simply responding and saying, "Well, I don't even know who this employee is," right? Or I don't have documentation of this e-verify case number. It's important that you're being deliberate about the way that you're responding to the government, because they may not be collaborative. They may just take your word for it. And so, it's important that you slow down, you take a review, you make sure that everything that's being requested is appropriate. And again, you speak with counsel before you actually respond, particularly if you're seeing some significant issues called out um, by E-Verify.
They can refer kind of egregious cases to IAR or even to ICE. And we have seen some IAR referrals.
I think it's very helpful, John, that you call that out, because one of the things that we have um, kind of consistently reiterated throughout this podcast series is, yes, maybe there are no fines associated with an E-Verify desk review, but there really is historic data sharing in between the different federal agencies that are responsible for a variety of different compliance investigations and enforcement methodologies. And so the E-Verify desk audit can simply be an entree point for the government to really dig into a variety of other, if they see patterns or practices related to employing unauthorized workers, or simply not meeting their I-9 compliance requirements. Maybe the next action is they're not hearing from E-Verify, they're hearing from HSI, and they're getting a notice of inspection. And then we're snowballing into more and more penalties, and really kind of a whirlwind of hurt for a company. And so, again, really important to our listeners to get their houses in order now before they have any sort of outreach from the government, to really save time and pain on the back end. John, this has been a tremendous discussion. I want to kind of close out by talking about what are the potential penalties, if any, associated with noncompliance. Because on one of our prior episodes, we discussed notices of inspection and how noncompliance with the I-9 requirements can really result in pretty substantial fines. And so, how do we contrast that with this kind of audit or review process?
Yeah. So I would say that so unlike traditional, notices of inspection, I-9 audits, where ICE is involved, there aren't any specific like paperwork penalties or fines associated specifically, typically with respect to e-verify in general. There is a potential fine if you knowingly continue to employ somebody who's unauthorized to work and you don't notify the agency. That's located in the MOU. But the types of things that we're talking about here, oh, you've got a bunch of cases that were late, you weren't following up with your TNCs, those types of things, which again are the types of things the agency is concerned about. But you're not going to get a quote unquote fine from that. However, the ultimate penalty that the agency has been kind of waving around is termination of the E-Verify program. It's mentioned a bunch of different times. I mean, from the very beginning, when you're first invited to participate, if you do not take action, you could be terminated. When you receive your quote unquote recommendation letter from the government, and if it has a discrepancy, again, let's say, for example, you didn't conduct any training of your users and you're unable you're unwilling to do anything about it, you don't take any action, again, within that recommendation letter is the threat that they will terminate you from the E-Verify program. And, in one sense, you might be saying, well, this is a voluntary program. If I'm kicked out, no big deal. But really the risk, I think, is, especially if some of these large organizations, you've got federal contracts that are depending upon this. You might have state contracts. You might be an employer that is, heavily using their remote document examination, the virtual I-9 process. All of these things depend on E-Verify. So, yeah, may not face financial penalties, but just, yeah, termination is a pretty big stick that is now being mentioned with these types of audits.
Yeah, and I can attest, throughout the process, it seems like almost in every paragraph of communication that you receive, they say, "Or we will, terminate your MOU," and it's particularly interesting, as you kind of alluded to, that you get a recommendations letter. And if you don't take those recommendations, your E-Verify usage could be terminated. So again, very important again for our listeners. Make sure that you are reviewing your MOUs, that you're standing by your obligations as an E-Verify employer, that you're being consistent in the ways that you are submitting cases, that you're working with your web service providers to really understand how their system works, who your points of contacts are, what is the escalation protocol with them if you receive an audit notice or a desk review notice, and really having a protocol in place so that all of the different parties that are associated with your compliance program can very quickly at least convene, if not act, if you get one of these notices. So, John, this has been a really tremendous conversation. I really appreciate your time. I think there were some really great key takeaways for our listeners. This is going to be, listeners, our conclusion of the Worksite Compliance mini series. Probably the first installment of many. So stay tuned. Do all the things that podcasts tell you to do, like follow, share, subscribe. You're going to see us on LinkedIn. Make sure that you check those notification bells so that you're immediately notified when we drop our next podcast. We have a few new series coming out after this one. Mr. John Fay, thank you for joining us today.
Absolutely. Thanks for having me. It was fun.
Thank you for listening to Statutes of Liberty, an immigration podcast brought to you by Klasko Immigration Law Partners. For more information, visit us at klaskolaw.com. Follow us on LinkedIn, Instagram, and Facebook. You can email your immigration questions to podcast@klaskolaw.com. The materials contained in this podcast does not constitute direct legal advice and is for informational purposes only. An attorney-client relationship is not created by listening to or accessing this podcast. The information provided should never replace informed counsel regarding specific immigration matters.